like many things in life, this conference was born of a particular moment. In 2016, I was 3 years into a job working on criminal code reform in the District of Columbia for an agency that now goes by the name of the DC Criminal Code Reform Commission. The district's local legislative body, the DC Council, tasked this agency with developing a modern, comprehensive criminal code for its local criminal justice system. So this kind of code revision project is valuable to any jurisdiction, given the bloated and unwieldy state of American criminal codes. But it's particularly important like a place like the district that's never really written its criminal code ever. You see, between 1960 and 1985, most jurisdictions in this country reformed their criminal statutes in light of something called the Model Penal Code. That's model draft legislation that was developed by the nation's preeminent law reform organization, the American Law Institute. The MPC offers a blueprint for producing a clear and coherent body of criminal laws, something you'll hear a lot about over the next couple of days. But the district never successfully completed this kind of MPC-based reform project, leaving its criminal laws in a general state of disarray. Working for the Criminal Code Reform Commission, my primary responsibility was to draft general mens rea provisions. This meant that I spent nearly all of my time trying to come up with criminal legislation, clarifying just how guilty someone's mind needs to be to convict them of an offense. The idea behind requiring a guilty mind is pretty straightforward, because a criminal judgment expresses something that a private judgment doesn't: moral condemnation. To be convicted of a crime is to be told that you failed to live up to society's moral expectations, and therefore deserve the communal disapproval and suffering that comes with being labeled a felon. But whether that's actually true depends upon at least two things. First, did you do something wrongful, which the criminal law told you not to do? This is what we call actus reus. And second, did you act with a blameworthy state of mind? This is what we call mens rea. The moral significance of mens rea is intuitive. The different mental states accompanying the things we do change the way others perceive them, even if the bodily movement is similar. Think of the difference between a push, a pat, a grope, a swipe, and a caress. They all largely involve the same movement, but the intentions behind them are distinct, and that can make a world of moral difference. So this moral difference is often pretty obvious. As Justice Holmes famously put it, even a dog can tell the difference between a stumble and a kick. But sometimes a bit more reflection is required, because there are literally infinite variations in mental state. For example, is the kick of a playful teenager or scared adult who mistakes a peaceful friend for an aggressive attacker really a kick, morally speaking? And is the stumble of someone who's extremely intoxicated or belligerently running around a NICU really no worse than any other stumble? Dogs probably can't appreciate these nuanced psychological differences, but humans can, and criminal statutes need to. Because when one human inflicts serious, irreversible harm upon another, people look to the criminal law to figure out both who's to blame and what the consequences ought to be. But there's a problem. Because legislators have historically done a poor job of drafting criminal statutes that protect those lacking a guilty mind from being prosecuted. Sometimes it's by design. So, for example, over the years, lawmakers have found it hard to resist empirically dubious ideas like punishing the morally innocent to deter others. In other situations, punishment of the morally innocent may be an accidental byproduct of poorly drafted statutes, because it can be surprisingly difficult for legislatures to communicate mens rea requirements in a clear and consistent way. So these are the kind of issues I spent most of 2016 thinking about, with the hopes of improving upon the mens rea recommendations of the Model Penal Code. Spending most of my waking hours in a windowless basement office, I lived in treatises, law review articles, cases, and statutes, steeped in the law of guilty minds. I think that for most people, this years-long focus on a single set of pretty abstract principles would have been a recipe for misery. But I was possessed, not only by my fascination with mens rea, but for a cause. You see, I'd lived in DC for more than a decade and had witnessed the mind-numbing racial disparities reflected in its local criminal justice system. The district is a place where more than 75% of Black men can expect to be incarcerated during their lives. In fact, by age 23, almost 50% of Black men have been arrested. So the idea that a city of mass incarceration and striking inequality would invest its limited resources in punishing morally innocent actors struck me as reprehensible. Because to my mind, there was little question of who suffers the most from such policies. The very same populations who bear the brunt of every other problem in our criminal justice system: the poor, the underserved, and people of color. So I was surprised when in 2016, a federal effort to bolster the relatively weak mens rea protections in the federal criminal code went down in flames. But even more shocking than its defeat is the fact that criminal justice reform-minded Democrats were driving the opposition. They tried to frame mens rea reform as a Republican boondoggle that singularly benefits large corporations and those seeking to pollute the environment. This was surprising to me as it was to others. Writing the New York Times, Professor Gideon Yaffe explained how the federal mens rea reform effort could be harnessed to aid some of those who are most often abused by the criminal justice system: the poor and racial minorities. His point was echoed in a public statement offered by the executive director of Federal Defenders of New York, who argued that public defenders are acutely aware of the need for mens rea reform, given its impact on the 80% of people charged with federal crimes, namely people who are Black, Hispanic, or Native American. But these arguments weren't enough to convince Democratic lawmakers, who remain singularly focused on the bill's impact on corporate prosecutions. Indeed, even the executive director of ACL New York pushed back against federal mens rea reform, standing in opposition to legal protections for criminal defendants. This response illustrates what Professor Ben Levin has described as a level-up approach to punishment, which holds that we'd be better off treating white-collar defendants just as poorly as a disadvantaged defendant of color, instead of providing greater justice for all. Ultimately, this bizarre episode left me with the sense that a corrective to the public discourse over mens rea reform was necessary. And about a year later, I had an experience which led me to believe that a corrective was possible. Because around that time, I was invited to present a paper on mens rea reform at the Theorizing Criminal Law Reform Conference in Camden, New Jersey. That conference was put on by the excellent criminal law faculty at Rutgers, and it offered a unique opportunity to meet and receive feedback from some of the mens rea scholars whose work I had spent years living in. The many conversations I had at that conference confirmed a couple of things I'd long suspected. The first is that respect for mens rea is an important part of a liberal vision of criminal justice. This is a vision where punishment isn't tied to morally arbitrary factors like race, ethnicity, or socioeconomic status. Instead, it focuses upon the same thing that grounds our everyday judgments of moral responsibility: human minds and the decisions they make. The second thing the experience confirmed for me is that mens rea reform holds the promise of improving our criminal justice system. By privileging the human mind over ethically suspect ideas about controlling dangerous people, we should be able to produce a system that's fair, more humane, and more equitable. So when I joined ASU last year and had the opportunity to organize an event for the Academy for Justice, I knew precisely what the topic would be, as well as many of the people I'd invite. The original plan for the conference was to hold a multi-city event with the intimate involvement of lawmakers. But since then, a lot's happened in the world. A global pandemic now spreads through our nation's jails and prisons. And a long overdue spotlight has been placed on the endless brutality and unjustified violence perpetrated by law enforcement against people of color. With these developments, the goals of this now virtual event have become more modest. Because with a criminal justice system in crisis, it's fair to question just how much of a priority mens rea reform should really be at this particular moment. At the very least, it's clear that focusing on moral innocence is not going to unravel mass incarceration or eliminate structural racism from our criminal justice system. But that's also true of just about every other politically realistic reform proposal being discussed right now. And mens rea reform also has several things going for it that many other proposals don't. For one thing, it's connected with our intuitive sense of justice. It's also aligned with some of our nation's shared moral values, and it offers the promise of narrowing liability for even very serious crimes in a just and equitable way. So I still do think there's an important conversation to be had, not only about mens rea reform, but also about guilty minds and why we care about them. Because mens rea is a fascinating topic that touches upon some of the most fundamental questions in life. Things like, what does it mean to be human? Why do minds matter? And what mental states are morally significant? So if nothing else, this conference should provide an opportunity for us to reflect on these and other important issues over the next couple of days. Okay, so with that, we're just about ready to get things started. But before we jump into the first panel, I just need to offer a few words of thanks. So first, I need to say thank you to everyone at the Academy for Justice. That includes my wonderful criminal law colleagues, Professors Eric Luna, Felina Beatty, and Ben McJunkin, as well as Vice Dean Adam Chodorow. And it also includes the amazing A4J staff, Dawn Walton, Jennifer Jost, and Suzanne Stewart. It's a true joy working with all of you, brainstorming ways to make scholarly ideas more accessible to criminal justice reformers and the public. I'm so grateful for all of your help with making this event possible. I also want to thank my other ASU colleagues, including Executive Dean Zach Kramer and Professors Josh Sellers and Laura Cordes, for many helpful conversations and insights about this event. And thank you as well to the Dean of ASU Law School, Doug Sylvester, for encouraging me to think big about this project and everything else happening at the Sandra Day O'Connor College of Law. It's also important to thank the many dedicated members of the Arizona State Law Journal, including the current EIC, Delilah Cassidy, and the previous EIC, Sarah Polk, who have all been essential to making this event possible. Thanks also to all of the event participants. In this incredibly uncertain time, it would have been understandable for you to have dropped out of this event to handle more pressing obligations, from the demands of online teaching to challenges with childcare, case dockets, or policy crises. It's a joy to have such a great group of academics, judges, and policy experts convene together in this one virtual space. This event would not be possible without your participation, so thank you. Finally, I need to give special thanks to Rachel Barco and Gideon Yaffe, who have generously provided me with invaluable feedback and advice on this project from its inception more than a year ago through today. And I also need to thank Paul Robinson and Ken Simons, who offered incredibly helpful feedback and advice at different stages of this project. One of the great surprises of being an academic has been the generosity of time and spirit that these and other scholars in my field have shown me, based on nothing more than our shared interests and ideas in legal topics. Our correspondence and conversations have been a real light in an otherwise dark time. So thank you. So with that, it's time to begin the conference. Our first panel is moderated by Andrea Roth. Andrea is a law professor at Berkeley Law who has 9 years of experience working as a trial and appellate public defender. Andrea, I'm now going to hand it off to you.